Hey, good afternoon, everyone. I'm Neil Kent, Senior Consultant for Contact Center Compliance and your host of our highly acclaimed Masterclass webinars and summits. It's my job to help clients navigate the complexities of marketing regulation and to define best practices. And in that, quite often, we find that, wow, I'm choked up from today. Often we find, boy, I can't even speak. Who wants to take over the intros? Often we find that our clients, people we talk to, really do strive to have compliant environments, but routinely we really do find that their interpretation of consent and SMS best practices creates opportunities for litigation. So we felt it important to help everyone understand and to discuss what best practices are, especially in light of last week's Supreme Court ruling. So a little housekeeping. This masterclass is not intended to give you legal advice, but although you do have some of the greatest legal minds and thought leaders on it, but in that point, please feel free to ask questions. We'll try to get to them. We'll try to ask them. As always, we try to follow up if we don't get to your questions. And so now it's my pleasure to introduce today's panelists, which really are TCPA royalty. Eric Troutman. Eric is one of the country's most prominent class action defense lawyers and is nationally recognized for TCPA litigation and compliance. He is a partner of Squire, Patton, and Boggs. Eric has served as lead defense counsel more than 250 TCPA class actions and has litigated over 1,000 individual TCPA cases. Eric is truly the czar of TCPA world, and please make sure you are a regular reader of Eric's blog, www.tcpaworld.com. He also has an awesome podcast. Along with Eric, I'm proud to introduce Pooja Amin, and you've seen Pooja on our classes before. Pooja, of course, has the title as Queenie or Queen. Pooja is the corporate counsel overseeing marketing compliance and litigation defense for one of the nation's most highly regarded mortgage originators, Loan Depot. Before joining Loan Depot, she was a critical member of the czar's team where she defended some of the nation's largest financial institutions in TCPA matters. And our special guest today is Aaron Christopher Evans. AC is a pioneer in conversational marketing, as well as co-founder and CEO of Drips. Drips is the first conversational texting company of its kind, and it founded a new category and leading the way in some of the biggest brands in the world to use automated, humanized conversations, but at scale. AC, and if you've heard him speak, and I've had the pleasure of doing that, he really is a proven thought leader, and he's here today to share his vast experience in performance marketing, consumer retention, and entrepreneurship. And with that, as I can barely speak now, which is probably a good thing, Eric, I'm going to turn it over to you.
Hey, everybody. Thanks so much for joining us today. Really excited. This panel is fantastic. If you don't know the Drips product, you really should. It's like one of the best, most innovative platforms. And I'm happy to count on guys like AC as true innovators as amongst my clients. And of course, Pooja Amin, I mean, what can I say? At Loan Depot, is there a stronger brand right now in the nation? And these folks have done such a tremendous job really kind of building themselves in the fabric of American society. They have a ballpark named after them. And here we have the head of their marketing legal department, Pooja Amin, joining us. This is really cool, really exciting. We're going to talk mostly about SMS messaging today. Unfortunately, because of Facebook, the big ruling from last Thursday, we're going to have to talk about that a little bit. That wasn't frankly going to be on the agenda originally, but since we've got a really big important story, we're going to have to cover that. That means I'm going to end up talking more than I wanted to talk. Frankly, AC and Pooja are the real geniuses here. I'm just kind of in the way. Nonetheless, we've got to kind of tee up some of the legal issues so that they can really kind of help from a practical perspective. So let's go to the first slide and kind of start moving through. As Neil said, if you have questions, ask them. No guarantees we're going to get to them, but we're going to do our best. Lots of content as always. 50,000-foot view of prior express consent with the TCPA. I guess I should say this is we're mostly focused on consent today, folks, which remains the gold standard, the holy grail, the thing that you need most to assure bulletproof satisfaction of the TCPA and the Dnc rules. If you have express consent or written express consent, depending on what kind of message you're sending, you don't have to worry about anything else. You don't have to worry about Facebook and its implications for you. Although, as we're about to see, I mean, there are some pretty big implications. But what we're looking for right now is talking about consent. And actually, you know what? Why don't I have Pooja and AC real quick just say, kind of at a high level, folks, in light of Facebook, which we're going to talk about, I mean, are we departing from our best practices so far just right out of the gate, or are we still thinking consent is the gold standard? Should people just leave this webinar because it's not going to be useful because we're talking about consent?
Business as usual here. Nothing's changing on our end.
Yeah, same. Nothing from clients of ours like Pooja's has indicated anything other than business as usual. I don't think that big brands and whatnot are going to try to exploit this. There's also a ton of different considerations, which I'm sure you'll get into, Eric. But this doesn't mean that you can just go buck wild. There's still the pre-recorded, parts of TCPA that stand, and lots of others.
All right, so good.
Eric,
That's gratifying. Consent still matters. So, go ahead, Neil.
I was going to say, so consent is the absolute gold standard. So maybe TCPA stands for total consent protects all.
That's brilliant, Neil. I mean, I've heard TCPA be referred to as total cash for plaintiff's attorneys. I've never heard of total consent protects all, but that's brilliant. I really like that. I'm gonna start using that if that's okay. All right, so at a high level, okay, what does the TCPA require? You have to have the express consent of the called party in order to leverage automated technology. That's going to include automated text messaging, and to make any pre-recorded or artificial voice call to any cell phone or to any landline for marketing purposes. That's going to include ringless voicemail. It's going to include IVR. It's going to include messages that are played live. It's going to include messages that are left on voicemails, okay? Any sort of artificial or pre-recorded call, including a call that is a live call, but that starts with a snippet like, this call may be recorded for quality assurance. That's potentially going to trigger the TCPA automatically, even if the call is not auto dialed. Okay, something to keep in mind. This is going to survive even post Facebook. And this includes calls that were initiated using, for instance, a predictive dialer where somebody's not available to take that call. It hits your abandonment rate cap. You're making a marketing call. So of course, as you know, within 2 seconds, you have to then play a pre-recorded message indicating the purpose of the call in order to comply with the TSR, which I know you're all doing. That pre-recorded snippet would also qualify as a pre-recorded call under the TCPA, for which you would need consent. So think that through, as you can tell, this is not TCPA 101, folks. We are at an advanced level. This is a master's class. I'm assuming that all of you are already masters. I'm kidding. But really, we're going to get a little bit more granular than we usually do. We're going to have denser slides. Most of you have probably seen my content before. I love to keep it 50,000 foot. I love to keep it accessible. Today, we're going to be a little bit more nuanced, a little bit more down in the weeds. All right, so beyond just the TCPA, we also know that there is the DNC, the National DNC Rules. These rules track closely, but are not quite identical to the TCPA rules. So that's something to keep in mind. But the DNC is more critical than ever before for reasons that you're going to find out as we go through the content today. DNC rules, critically important. Again, with the DNC, you're going to have express written consent for consumers who are on the national DNC list when you're trying to contact a residential phone number. If you have a established business relationship though, or an inquiry, somebody's reaching out to you to talk about your product, then you don't need to have that really high level of this express consent. Really kind of interesting nuance of the Facebook is potentially leads that come in that don't have true express written consent might now be subject to automated text treatment that they couldn't have received before because the DNC inquiry rules are lower than the express written consent rules that the TCPA would have applied. So even if that cell phone number is on the DNC because of the one-to-one interaction of, for instance, an API push from a web form submission, you might be able to utilize that text technology in that setting. We'll talk about that in a few minutes.
Eric, a question that's relevant to that. So on an inbound call, somebody says, is that consent? But on an inbound, that's an inquiry, and don't inquiries have expirations to them?
Okay, so perfect. So, and you put your finger right on something critical, right? Pre-Facebook, the inbound call setting was a really challenging situation for people to capture consent, right? Because if you want to talk to that consumer in a subsequent phone call about a marketing purpose, right? Caller comes in, says, hey, I'm interested in buying some widgets. Tell me about your widgets. Yeah, sure, happy to talk about the widgets. Consumer says, oh, hey, you know what? I got to run. Bye. You want to call that customer back to talk about widgets, right? I mean, that's plainly something that you're interested in, and they are interested too because they told you that. Pre-Facebook, you still have to have the prior express written consent in order to use automated technology to call that phone number back. Post-Facebook, utilizing one-to-one text messaging technology, you're probably going to be okay. We're going to talk about why. And the nice thing is, as you just pointed out, Neil, that inbound phone call is plainly an inquiry about your products and services. The customer asked you about widgets. That creates an inquiry, and that means for 90 days, it does not matter that that phone number is on the national DNC list, you are allowed to call it. Now, that doesn't mean you're allowed to call it 62 times an hour, but you are allowed to call it, and that includes text messages. Make sense? Next point. All right. By the way, Pooja and AC, again, your voices are, I think, more valuable, frankly, than mine. So feel free to chime in at any point, okay?
I think you just hit the number. You're asking what changes. I think two things. One, companies can start to do the things like that you're talking about, Eric, right? Like somebody calls 1-800 the general, but they can't get to the number quick enough, or they call and invoke a tracking number, and that enterprise knows that the person was interested in said product. Prior to this, that was a dead space that you couldn't really touch, right? Post this, I think that is the kind of thing that you'll see enterprises starting to get a little more comfortable with, because there's less of a fear of the pro plaintiff out there.
Yeah.
So it's those tasteful
right.
moments that now aren't blocked by previous law.
Yeah, and I love it, Neil and AC, that we were able to kind of put our fingers kind of right at the gate on something, because people are hammering me, as you'd expect. What can I do different? What has changed? And by and large, we're preaching, be conservative, go slow. But we are also looking for places where it's like, okay, this little carve out, this feels pretty safe now, right? And the use of, again, one-to-one texting technology or P2P texting technology or P2P calling, right? We're going to talk about why that's still important, that we're doing it on a one-to-one basis and not blasting, right? Blasting is still not safe. You're going to find out why in a moment. But the one-to-one interactions, particularly in the inbound call setting or in the web form submission setting, where maybe you don't have complete express written consent, right? Maybe that web form submission isn't quite where it needs to be. Now, all of a sudden, we can soften up a little bit and leverage some of these one-to-one technologies that we couldn't have used before without too much fear of litigation. So that's a nice thing. All right, next slide. I tried to break these rules down in a way that is useful. Again, we're focused on consent right now because consent is your magic bullet. You've already heard us kind of talking about questions around technology. We're going to get to that. But consent is where you want to focus, because if you get that consent, then the technological evolution changes questions. And in fact, piece 2 of potential legislation that might be coming out of Congress, all of that is going to be kind of secondary or maybe just noise to you, because you're going to have that consent that you need. And fundamentally, the consent rules have not changed. Nothing about Facebook changes what you have to have in terms of consent. The only thing Facebook does potentially is limit the number of instances that you need consent. Okay. If consent is needed, the same rules that applied before still apply. Nothing has changed. The only thing that has changed potentially is that now you're not going to need consent in as many instances. Okay, I hope you understand that. The consent rules didn't change. The first thing people have been saying is, so can I change my disclosure forms? Okay. You can change your disclosure forms if you are comfortable that you don't need consent at all. If you need consent, you still have to have the same forms. All right, I can't say that more plainly.
Another thing to add on with the technology side, I'm sure many, if not everybody that's on this channel now is aware of the changes coming with 10DLC and the campaign registry. And, just like if you signed up with a Twilio account or almost any texting platform, you have to agree that you are following best practices set by the CTIA, which are very, very similar to what we pre-Facebook, right? Like consent, express, it's written, it's obvious, it's captured. So it's not just just because the law has changed a little bit does not mean that the technologies and the filtering companies are going to, open it up and say, all right, do whatever you will, do whatever you want. They're still going to expect you to kind of follow these best practices.
Yeah, the carriers continue to wield tremendous power in terms of deliverability. And we're going to talk about that toward the end. I think there's a real constitutional problem with that, but we'll deal with that kind of as a separate segment. But you're absolutely right, AC. We can't just depart wholeheartedly from the frameworks of consent that we had before, even if we wanted to, because it doesn't mean your message is going to get through.
As I was gonna say, you could try, right? Just like you could try to email 1 million Gmail accounts today, from one IP from your house. It probably won't work out very well.
Pooja, bringing you into the conversation real quick. I assume Loan Depot, which I think is public record, does work with lead providers. I presume you're going to require the same high standards in terms of the disclosures.
I mean, just the same high standards we've been dealing with up to date, right? As we talked after the ruling came out, Eric, frankly, nothing changes on our end. If anything, my onboarding process and vetting process becomes a little bit more stricter, because I don't know how folks are going to interpret it on their end. But, for Loan Depot, it doesn't change. And for the vendors such as Drips that we work with, our expectations for them don't change as well.
So I hope you all heard what Pooja just said, because she's adopting this very understated approach this morning, which I appreciate. Her vendor reviews become stricter as a result of Facebook, not less strict. Because when you're working with third parties, right, you are of course going to be potentially bound by what they're doing. And so if you're an enterprise that is buying leads, or if you're an enterprise that is using a vendor, and those lead suppliers, performance marketers, or vendors, including platforms, are taking an aggressive view on Facebook, and you're not comfortable with that, you need to make sure that they know that. There needs to be clear communication with these vendors, these lead sources, where you are advising them that I still expect gold standard consent. I do not want to see any disclosure language changing. I don't want to see the position changing. I don't care, right, that Facebook has come out. My institution is going to continue to abide by best practices and make sure that consumer contact preferences are met, and that transparent disclosures are given to consumers before I will accept a lead, before I will allow you to make a phone call. Okay. So Pooja, thank you for that.
And I think that somebody asked me recently, they said, well, I guess I don't need Jornaya or Active Prospect anymore. And I said, absolutely not correct, right? Like you really need those third party, Pooja really needs those third party tools to be able to see what's going on, to see what's changing, to make sure it meets Loan Depot's level of standards. And same with Drips. When we get inquiries to whoever it may be, Eric, you deal with a lot of these, like that third party, audit of it, whether it's a pre-check or a radio box or, not, or whatever, is super important. I think a lot of companies are probably going to feel a little more emboldened. Like one I always use, and I can't remember if you've looked at it before, Eric, but it's like cars.com, like their consent has been, and it, for years, it's just like, we will text you, right? It's like, and there's just like a statement. It's like right under the submit button. But the law doesn't say it has to be a pre or post, radio or whatever. I don't believe. So that's the standard that they took. So maybe they feel a little more emboldened by that now.
Let me throw something out to Pooja and to you, AC. As marketers, we do a lot of form testing. As advocates for consent, you heard what I said at the top of the thing. For the clients that I do, those who institute a full TCPA consent, right, or it's an agreement, have not seen a degradation in response to their forms. And so I'll ask you guys, have you seen that, right? Just because I add the consent, most people don't want to add consent language because they're afraid it's going to impact conversion.
Yeah, but let's be clear, it will impact conversion depending on how many barriers you put to entry, right? Like if you have a thing that pre-checks somebody is already opted out versus a statement like on cars.com, there are varying degrees of how much friction you can put between a consumer and submitting a form, and that's a business decision, I think, right? And you also got to know that if it's not too crazy and people go through it, those are going to be the ones that are going to be more higher propensity to buy, right? So some friction, I think, is actually super healthy, right? It keeps Loan Depot from having to have twice as big of a call center as they have to field a bunch of not interested parties. People that are really interested in working with them are going to check what they need to check or uncheck what they need to check, or, hit the submit button and read the disclosures and whatnot. And those are going to be the interested parties.
Yeah, and just to back that up, I mean, every element of transparency in the process you provide to the consumer is qualified, right? Every element that you say, and this is exactly what's going to happen next, and that consumer wants to take that journey with you, that is just an additional qualification that that consumer is interested in your product and service and wants to be in your ecosystem. I preach constantly that there should be no surprises. There should be no surprises. There should be no hiding. There should be certainly no baiting and switching or deception. I mean, that at the far end, of course, everyone knows that's not okay. But really, you should lean toward as much transparency as you possibly can in terms of what the outreach is going to look like, how it's going to take place, what channels you're going to be communicating through, and of course, what phone numbers you're going to be contacting them on. I think kind of all of that fits together to assure that that consumer is actually going to want to hear from you and that those contact preferences are met, which is going to mean, ultimately, to AC's point, yeah, look, you're going to lose some leads. There's no question about it, but the leads that are going to come through are the ones that are going to convert better.
Yeah, and there's almost always, like, companies that are just implementing this and they're worried about form conversions. There's almost always other efficiencies they can find on the form, right? You can, instead of taking somebody's city, state, and zip code, take their zip code and get rid of the city, state field. Like the 2% that you lose because of the consent piece, you'll gain back because you have 2 less fields on the conversion. It's just all about friction, right? The less friction on a form, the more throughput you get on it, the end. So if you got to add something, try to trim something else up is what we always, try to direct our clients to do.
And try to engage with your caller or your consumers at a time when they're most engaged, right? At a time when so that's why you want to stay away from older leads, promote in-store marketing, getting that verbal consent through, a conversation they're having, have them dial in, use your own internal website. There's other ways you can market to get those folks that are actually engaged, and you're going to get way better turnaround with that.
So on the slide here that's been on the screen for some time and growing stale, I put together the rules, okay? It's complicated stuff. Even after Facebook, the truth is that the consent regime for marketing and for non-marketing calls in the United States is it's a bit of a labyrinth, frankly. And as I was putting together this little visual here, well, it's not a visual, these are the rules. I started visualizing in my mind kind of what a flow chart would look like, what like a logic chart would look like. And I spent about 4 hours putting one together. I don't know where it came from. I was just sitting here and, it was like 6 o'clock. I started working on it and I look up and it's 10 o'clock at night by the time I got it done. But go to the next slide, because I think this is going to be helpful. I've never seen anyone else try to put something like this together. Actually, this is information for go to the next one. Sorry, we'll come back to this slide. We're going to talk about this slide, but let's go forward and then we'll come backward. So here is for informational calling. I just want to talk through this real quick, right? Just so you guys understand the rules of the road. If you're making informational calls, the whether or not and the degree of consent that you need is going to depend on whether or not you're using a pre-recorded voice, whether or not you're using an ATDS, and whether or not you're calling a cell phone. As you can see here, this is not particularly complicated, right? For informational calling, if you're not calling a cell phone and you're not using a pre-recorded voice, then you don't need consent. Okay? If you're not calling a cell phone and you are using a pre-recorded voice, then the chances are, and this is for informational calling, not for marketing, for informational, not marketing. Next slide is going to be marketing. This slide is informational. Then there's some new call restrictions that are in place by the FCC for informational calls in terms of the number of pre-recorded calls you can make. You can see it's 3 attempts per month or less to landline. If you're staying within those guide rules, no consent. If not, you're going to need, currently, because of some confusion with the way the CFRs are set up, you're going to need written consent for informational calls to landlines using a pre-recorded voice, which is kind of weird. But then if you're calling cell phones, of course, it's a whole different, you can see on the left-hand side of the flow chart, it's a different kind of dichotomy where you're going to look at, are you using a pre-recorded voice? If not, then are you using an ATDS? And yes, these slides are going to be available to you folks. I'm going to put these up on tcpaworld.com as well. So they're going to be available to the wide world. I just give away this stuff. It's crazy, but in any event, So this right here, if you're looking at the slide, you see this ATDS question kind of center left. Okay, that ATDS question, right? You've got the yes or a no. If it's a no, then you don't need consent. If it's yes, you're going to require consent. Okay, that's the little box in this whole flow chart where the Facebook decision is going to have the most impact. All right, so let's go to the next slide. Again, just want to walk through these visualizations real quick with you. Okay. It looks like my color got changed when it got converted to these slides. That's okay. So this is for marketing calls. And you'll see there's kind of a lot more logic here. It's a little bit more difficult. I'm not going to be able to walk through every kind of permutation with you. But
This looks like the should I buy a boat flow chart. You know,
you should buy a boat. Yeah, that's the outcome here. But as you can see, even when you're making marketing calls, there's going to be some instances where no consent is going to be needed, which is weird, right? Because you think, well, for a marketing call, no matter what, you're going to have to have consent, but that's not necessarily true. On the other hand, right, there's going to be a lot of instances, these should be red, these boxes in the upper right-hand corner and upper left-hand corner, where express written consent is going to be required, all right? Not any other form of oral consent or implication consent we talked about earlier, right? When Neil said, well, they called in, right? And they gave me an inquiry so I can call them back, right? No, where express written consent is required, this is like a really steep, like very dangerous form of consent that it can be challenging to obtain, although we'll talk about ways to make it easier. So this is going to be your flow chart here. Yes, this is going to be available to you. Hopefully this will answer many questions. Again, I don't think anyone's ever tried to put together something like this before. If somebody has, I've not seen it.
It's a complicated flow. Hey, Eric, would you address, because I know we keep having questions and it's in the industry, RVMs. And RVMs, let's say specific, ringless voicemail, sorry folks, to cell phones not on the DNC. It's a marketing message. And the Facebook decision didn't change that, right? For the most part, ringless voicemails generally have some sort of pre-recorded message. So it's not the ringless voicemail, it's the pre-recorded message, correct? That is still requires consent.
So we're front loading the consent discussion because this is a consent seminar, but we're going to have a technology discussion here in a few. But yeah, ringless voicemail, completely still covered by the TCPA. Facebook does not change at all in any way, shape, or form the ringless voicemail rules. They're still a pre-recorded call. So when you look at this flow chart, anytime you see pre/artificial voice and you're using ringless voicemail, the answer is going to be yes. Okay, and you'll follow the flow, and you'll see anytime there's a yes from pre-artificial voice, it's going to flow straight to express written consent. All right, that's going to happen every time.
And Eric, that's everything except a person, right, leaving a voicemail. I mean, that could be text to speech, that could be avatar, that could be pre-recorded, that could be the robot, you know, whatnot, correct?
Yeah, I mean, so if you're leaving a voicemail and it's a human being talking on the voicemail, hi, this is Eric, right then live, that's not pre-recorded.
Right.
If though you're leaving, people do this, people get very confused, right? It's very common, let's just say real estate agents, right? Very common. They will record using their own voice. Hi, this is Eric. I see that you're in my neighborhood. There's been some great sales. Give me a call back. You might want to sell your house, right? Then they will use technology that will call a customer. They're trying to talk to that customer live, but the customer isn't available. It goes to their voicemail. Rather than that agent want to repeat themselves over and over again, they'll just push a button to play the pre-recorded voicemail. Okay, that feels very manual, right? It's a manual call. It's a manual button pushing the message that was actually recorded by that person. That feels like it shouldn't be covered by the TCPA, but it absolutely is. That is a pre-recorded call. The courts have been very clear. There's dozens of cases that hold that. Okay, so we've got to be very careful. All right, so let's go back 2 slides. I apologize. I don't know how I don't know. Maybe this is my fault. In any event, so you've seen, hopefully everyone knows, everyone listening knows that there's a big difference between informational calling and marketing. Huge difference. In the informational context, right, the level of consent that you're going to need, as you just saw from that flow chart, is much lower in most instances. In many instances, you're not going to need consent at all. And when you're making informational calls, you don't have to worry about the DNC. Informational calling to numbers on the DNC is not prohibited. Pretty cool, right? So that is a powerful tool. If you can shape your messaging to make sure it's informational, then you're going to have a much lower consent threshold. On the other hand, if you're making marketing calls, right, calls that are introducing goods or services that are for rent or for sale, pretty broadly defined. If that message is in any way a marketing call, you're going to need a much higher level of consent. Again, you saw the flow chart. If you're using pre-recorded voices and if you're using an ATDS to contact a cell phone, and in instances where the phone number is on the national DNC and you don't have an EBR or an inquiry. I know it's a mouthful, but I gave you that visualization so you can kind of work through it. Then you're going to need that express written consent. And we're going to talk in a little while about how difficult that can at times be. And that's what we were talking about earlier about, are we going to dial back our express written consent disclosures in light of Facebook? And you heard AC and Pooja saying that's not what responsible businesses are doing right now. Okay.
Hey, Eric, can we, I'm just curious. So with this, we get a lot of inquiries from enterprises that want to reach out to their consumers, which, to upsell essentially, right? And they, sometimes I think there's a misconception that if you're not selling something net new or upselling, the best example I have is like somebody just turned 25 years old and they can save money on their auto insurance, right? That's still marketing, correct? Because you're changing the policy in a way that benefits the enterprise. Even if it saves the consumer money and the enterprise makes a little less money every month, and it feels like it was an administrative type news, alert, it's still to the benefit of the enterprise, which is essentially expands the lifetime value of the consumer versus asking Neil to get on auto pay, right? Like that doesn't change the policy. So is that a good kind of line in the sand? Like if it changes the policy in any way, good or bad for the monthly bill, that should be considered marketing. I think the upsell piece gets a little gray in a lot of people's minds.
Yeah, the rules around informational versus marketing are gray. They're all gray. And they are very challenging, frankly, to dissect. We're going to talk about this allergen case right now, which is really interesting. But upselling of any kind, even if, to your point, the upsell is actually a downsell in a weird way, is going to qualify as marketing. All right. And the reason is very simple, because when you are talking to somebody about saving money on their auto insurance, you are offering a good or a service for sale or for rent. It doesn't matter that you're actually going to make less off that consumer than you were making before. What you are doing is talking about a product or a service, the end, right? And of course, the famous case of the Abdullah versus versus FedEx, where FedEx was basically sending messages to customers to let them know, hey, look, your package is stuck in customs. It can't get through customs. We're sorry about that. And the court said that's marketing. And the reason the court said it was marketing is because when Facebook notified customers of that fact, the customer would call Facebook and say, well, why do I keep saying Facebook? FedEx. They'd call FedEx and say, what do I do? My package is stuck in customs. And then FedEx would say, well, we can ship it back to you for a fee, right? So the court viewed that message as the introduction, essentially, of a marketing component, because FedEx was going to profit potentially from that message, even though facially it was informational. So you got to be very careful.
Eric, is that proximity to transaction? Is that a way to look at it?
I mean, the closer your message is to a transaction, the less likely it is to be kind of a new sale. And assuming that you had consent in the first instance, again, all of this assumes that consent is necessary. Again, Facebook changes that to a degree. But if consent is necessary, then the odds are going to be pretty solid that you've got the correct consent for the correct scope, for the correct product at the time of sale. And over time, that's going to change, right? Meaning that the consumer is buying what they want at the time that they provide that consent. Then over time, you're going to try to introduce something new to them. Now, I will say that express written consent does not expire, okay? So going all the way back to AC's original example of an insurance product, let's say, we'll pick on Geico because they've got those fancy commercials all the time. You submit a form for Geico in the first instance about auto insurance. If that form is drafted correctly, it can say, I'm interested in receiving information about insurance today, and if I'm later a policyholder, receiving additional information later. regarding things that might be to my benefit, promotions, etc. You can draft a disclosure that covers both a product for sale today and for products to be sold in the future. And I'm going to tell you, that's kind of, what cutting edge businesses are looking to do, because what you want to do is bring someone into the ecosystem, of course, and then be able to continue to market to them. That's the challenge, right? But it's interesting because I feel like people are finally waking up to the reality that, hey, look, we've got all these customers. We've got a bunch of additional products or services that we want to continue to sell to them that they're actually going to want. And to AC's point, that sometimes we'll save them money, but we can't touch them anew because the original disclosure, the original consents weren't broad enough to let us do it. But if we drafted our original consents properly, we can sell them in the first instance, and we can continue to keep them informed and engaged later, right? That's the trick. That's the real trick. But let's talk about this difference between informational and marketing, because it's really very critical. And I'm going to tell you, it's not intuitive, right? The courts are very aggressive when it comes to interpreting messages as marketing. And this allergen case is a fantastic, it's a fantastic example. It's from March 16th, it's just 2 weeks ago, okay? So first I want to highlight, we'll talk about it again later, the VP of marketing and the VP of digital strategies and sales for Allergen are personally named in this class action lawsuit. And here's what happened in this lawsuit. Fantastic. Allergen is selling its Botox product, right? It runs an ad on television. This shows you how dangerous the TCPA is, or was. Runs an ad on television that says, are you interested in Botox? Text SAVE to this short code and see if you qualify to receive free Botox or reduced price Botox, okay? Short code, SAVE, right? And plain kind of call to action for consumers to engage with that short code. Plaintiff sends a text to the short code, SAVE to the short code, right? Does exactly what the ad says to do. First text comes in, and it's right here on the screen. I put them all down here because I thought this was remarkable. Okay, first text that the consumer receives, they're California. Please note that Allergen has an additional California privacy policy that you can view at allergen.com/privacy/CCPA, right? Right there, black and white, just, hey, look, you're a California consumer. We got to give you some additional disclosures. Hopefully you all know about the CCPA. Of course, Squire has a very powerful privacy team with the new addition, Alan Friel, who's all over this stuff. If you have questions, you can always reach out to us. But Allergen decided to try to get its privacy policy in front of this new customer with whom it's never engaged before through its SMS platform process on the first text message. Watch what happens, okay? Anyway, second message comes out. Are you eligible for Botox savings program, right? This is what the consumer engaged with Botox about. You can see it right here. I'm not going to read it all. You can see it's a very straightforward form, just asking a question, right? They're not pushing Botox. They're not saying Botox is the greatest thing in the world. I'm so glad you're interested. Nice, clear form. Then text 3, are you still interested in Botox, right? The next day, the consumer doesn't respond. So there's a second engagement on day 2, and that's what text 3 looks like, okay? Plaintiff sues Allergen. And as I mentioned before, the officers and compliance employees at Allergen who dreamed up this program. Allergen moved to dismiss and say, hey, wait a second. The guy engaged with the short code. He intentionally sent us his phone number and said he wanted information. This is plainly legal. And the court said, no, it's not. No, it's not. The court said, these texts are marketing, and you cannot market to a consumer unless you have express written consent. And this consumer just texted in response to a television program, so you cannot possibly have express written consent in the form that is required by the FCC. So per se, you lose. Your entire process fundamentally violates the TCPA. And this is a class action with the individual officers that came up with it personally named in this thing. This is a complete and utter and horrifying train wreck. How did this happen? Well, one, there were some really, in my opinion, strange defense moves that were used here that shouldn't have been raised at the pleading stage, but we'll leave that alone. The first text, right, because it did not pertain directly to the question that the consumer was asking about, was found to be outside of the scope of the information the consumer was seeking and therefore potentially marketing. And although this text does not mention Botox or allergen, the court found it could be pretextual, meaning that it essentially introduces and makes it possible for Allergen to sell to this consumer by providing this privacy policy. I just share this example because of how dangerous this world can be. Now, I will note that these folks are probably going to be just fine because of Facebook, right? Because this is a one-to-one texting interaction. This case was decided on March 16th, right before Facebook. Begs the question as to why the defense didn't move to stay the case pending Facebook, but leave that alone. After Facebook, in all likelihood, these sorts of interactions are not going to be covered. So let me pause here. I don't know, AC or Pooja, if you kind of want to share some thoughts around this case, or we can just kind of move on. But this highlights the difficult quandary of determining whether you're informing a consumer or marketing to a consumer. Crickets. Okay.
I would say that the best practice I've seen is if somebody could consider it, marketing is probably marketing, right? The end.
Yeah, it's just best to treat, purely informational calls. If it strives away from that, then it's going to be marketing, right? If it's not purely informational about the product that you're servicing your consumer on, or the one that they consented to, it's going to be marketing.
And we've another thing I think that people may be able to do is define the use cases, right? Like getting somebody to pay their bill, not marketing. Collections, not marketing. Getting somebody to enroll in auto pay, not marketing. So taking the time to like really build out, your business's consent matrix, if you will, and defining the things that aren't marketing and assuming everything else maybe is, right? Until you've greenlit it. And Eric, we've done a lot of that work together, right? Like figuring out like, is getting somebody to go into auto pay or adopt a portal or install an app marketing, or is it not? And there's a lot of use cases, but they're finite, right? In this world, there's not like there's thousands of use cases. There's a handful of dozen, a couple dozens, so taking the time to review those and kind of whitelist them is what I would suggest.
Yep, I agree with AC. I mean, the obvious one for Loan Depot would be offering a refinance product when you're calling them about the loan that they're already on. That's clearly marketing. You're marketing a completely different product, even though they're already one of your consumers. So
yeah, and I think if the point is to upsell, right? Getting to your word tricky, Eric. Like if we've seen this with various different requests to do education, campaigns where it's like, did you know that this time of year you should be watering your lawn, blah blah blah. Like if the point is to generate an interest and inbound message to upsell, then it's again probably marketing.
Think about your intent.
Yep, the intent, exactly.
All right, so this slide, if you take away nothing else from this presentation, hopefully this slide kind of drives home the importance of getting that express written consent, right? This is why consent is so important. It's why we say it's the gold standard, it's the holy grail, because if you have the consent, then situations like this won't happen to you. And hopefully you're understanding that call to action in a television setting, in a print media setting, it's very difficult to pull off. It can be done. It can be done. You can send instant one-time informational messages regarding your products or services that the customer specifically asks for, but it's tricky, as Allergen demonstrates. And if you get it wrong, it's a class action and it could be certified. All right, so let's move forward a few slides because I want to talk about technology now. At long last, get to this thing called Facebook that we've been teasing. All right, so at a high level, okay, Facebook says it's good, right? Essentially, you have to use a random or sequential number generator in your system. Otherwise, you're not using an ATDS, right? Before Facebook, some jurisdictions have found anything that calls from a list of numbers, it automatically is an ATDS. It is covered by the TCPA. So for instance, predictive dialers were 100% covered by the TCPA in most jurisdictions. Blast texting platforms were 100% covered by the TCPA in some jurisdictions. Post Facebook, these technologies are probably no longer covered, and some technologies are definitely no longer covered because they don't use a random or sequential number generator. but there's a little bit of gray here, still a little bit of gray, and it's footnote 7. I've been talking about footnote 7 a whole bunch. I figured I'd actually like put it on the screen for you, okay? A lot of this is legal stuff, right? I know some of you are lawyers, you can easily digest this. Some of you aren't lawyers. For those of you that aren't lawyers, I don't want you to waste your time reading anything until you see that word for instance. Okay, this is where it matters. For instance, an auto dialer might use a random number generator to determine the order in which to pick phone numbers from a pre-produced list. It would then store those numbers to be dialed at a later time. Okay. What is it talking about there? The Supreme Court, in a kind of a clunky and elegant way, remember these are like really brilliant legal minds, but they don't know marketing, they don't know technology. What they're talking about is list compilation, right? What they're talking about is how are you deriving a list out of a CRM or database to be passed into a dialer for calling. And as you see right there, if there is the capability of that system to operate in a dumb, unintelligent fashion in compiling those lists, that is to say, not using business rules or criteria, but just pull some numbers and put them in the dialer, that system might have the capacity to be an auto dialer, which is why if we move to the next slide here, there's a very clear now breakdown of technology that Facebook has given us. All right, so things are more clear. You know, there's a blessing here. Things are more clear than they were on March 31st, 2021, but they're not quite as clear as we would like them to be. All right, so I've put this technology here. Again, this is just Eric Troutman, you know, providing information, not legal advice. All right, anytime you're going to deploy a new solution, a new process, a new marketing plan, consult counsel, because if you don't, you might end up personally named in a lawsuit like the folks at Allergen did. Okay, it's just, I cannot highlight enough how dangerous this stuff is. All right, but again, high level, what we know is still red, right? The stuff that Facebook didn't change at all. Neil mentioned it earlier, ringless voicemails, right? Voicemails, any pre-recorded calls, IVR, and of course, calls to phone numbers, residential numbers on the DNC. Facebook doesn't touch any of that. All of those forms of communication still require express written consent, or in the context of a DNC, an EVR or an inquiry. All right, nothing has changed. Facebook did not change that at all. Very important to keep in mind. Now I'm going to go all the way to the green, right? Facebook did look at specific technology and blessed it, right? It said Facebook's interactive alert technology was not an ATDS because it operated one-to-one and did not use a random or sequential number generator in any way, shape, or form. What does that mean? That means that certain platforms, right? Interactive texting platforms, AI platforms, drips. Does that sound familiar to anybody? And of course, P2P texting platforms. It's funny because when Facebook came out, the P2P folks were afraid that Facebook just killed their business. It's the opposite. Facebook makes P2P and interactive technology extremely safe now. And yeah, I mean, it's weird to say this, but if the phone number is not on the DNC, technically speaking, not encouraging you, but I mean, realistically, you can deploy these sort of interactive one-to-one texting products without consent.
Little caveat there, Eric. We have 5 states that don't really like prospecting to mobile phones without consent. So at the federal level, it's one thing. There are states that have some issue with that.
And as AC will be quick to tell you, there's a lot of other issues with it too, because you've got deliverability restrictions from the carriers. You've got, brand protection and giving consumers good experiences to think about as well. You don't want to sully your good name. And of course, you've got, hopefully soon, industry best practices and folks like Leads Council coming together and putting out these best practices that everyone can live by to ensure that consumers are still getting good experiences across an industry.
Hey, Eric, do you want to talk about or put or even discuss A2P platform? Is that in the yellow space?
Well, no, A2P should be one-to-one. I mean, A2P should be green in most instances. Now, there's going to be A2P protocols where it's not a one-to-one API, where you're, essentially, dumping big lists. And anytime you're talking about a blast text platform of any kind, you're going to be in the yellow. All right, and so let's talk about the yellow real quick, right? Predictive dialers, preview dialers, blast texting, all of that is yellow. And what yellow means here is that the systems are probably okay, right? It's just like when you're going through a yellow light at an intersection. You're probably okay, but you take on a little bit of risk, right? When the light's green, you're safe, and the light's red, you stop. When it's yellow, you're gonna make a decision, right? Either you're gonna blow through it or you're not. The reason why there's a little bit of risk here is because any of these systems, you just saw footnote 7, right? Any of these systems might have the capacity to operate in a way that makes use of random or sequential number generation in a way that a court in the future might deem to be an ATDS still, all right? Now, I think 90%, 95% of courts are going to look at Facebook and say, no, 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 no. Facebook says if you're not dialing randomly, you're not using an ATDS, period. Okay. So for those courts, all these yellows, they're essentially green. But there's going to be courts, 5%, 10%, probably all here in California, frankly. They're going to look at these technologies and they're going to say, no, there's too much latent capacity. There's too much, going on in the background. There's too much code out there that we don't fully understand. We're going to say it's got the capacity. We're going to say these systems still pass muster under footnote 7 and Facebook. So I put them in the yellow because you have to really understand exactly how these platforms are operating before you can dare to utilize them without consent. I would really encourage everybody that if you're using one of these yellow solutions, that you change nothing, that you just keep assuming that you need complete express written consent for marketing, express consent for informational calling, and just act as if Facebook didn't happen until the case law develops further. The green stuff, kind of going back to AC's point earlier, I mean, you can start looking at like very small ways to kind of change your practices to absorb a little bit more risk, because Facebook really did seemingly, again, at the federal level, give you a little bit of room here. Certainly a defense in litigation that'll be pretty stout. Now, again, that doesn't mean you want to harass consumers. You still want to apply best practices and think through logically what you're doing. But where that consumer has otherwise given you a transparent indication that they're interested in information, whereas the TCPA previously operated as a gotcha statute that was totally inconsistent with what you'd expect, good business practice to be. Now, around the edges, for instance, in the inbound call setting, you've got an opportunity to engage with those consumers in a good, transparent, honest way where you don't have to worry about TCPA exposure. It's a really nice thing. Okay, anyone want to chime in? Otherwise, we can go to the next slide. And look at that. Are we seriously already at the top of the hour? You guys
we're at the top of the hour. Hey, folks, a couple things. We're going to have a continuation. There will be additional sections of this. Plus, on your questions, we're not getting to a lot of them. I know I'll be reaching out to steer those questions to the right experts. So keep asking. Let's keep a record. Let's keep the dialogue going. But we'll get to everything. And whatever we don't get today, the team will be back. We're going to have it. Stay tuned and be ready to. In fact, we'll have probably the first Wednesday of every month will be a continuation either of some new topics called deliverability or of the master classes. But we'll get there.
Let's go to the next slide. At least let's get to Pooja's awesome slide. Queenie put this together. I thought it was so good. One more. And I'm just so embarrassed that we didn't get through this. It's my fault. I was talking too much apparently. So how cool is this, right? Queenie, do you just want to walk us through this? We got like 5 minutes. Just kind of walk through some of these tips and pointers that you'd like to see.
Yeah, I mean, after you folks have digested and gone through Eric's maze of yeses and nos and where you fall in, at the end of it should be your best practices, your company's best practices, and some do's and don'ts you should be teaching your employees and kind of embedding it in the back of their head. You want to be, they're quite obvious and simple, but you want to consistently remind folks. You want to be clear and upfront in all your text messages. Stay away from bait and switch, as Eric mentioned earlier. Be cognizant of the content you're sending. Like any other form of marketing with text message, you're sending it to something. It's very personal. So you want to be very careful of how you're wording things. You'll make it personal. Stay away from the obvious hate speech, profanity, misleading information, etc. You're going to get better customer engagement and, quite frankly, those are the folks who are going to be less likely to come after you for a TCPA or DNC violation. And it's just better brand reputation. And then I put a list of don'ts as well. If you want to go to the next slide, you know, along with like the state laws as well, you don't want to be texting too frequently. You want to be cognizant of when you can text. You know, some states don't allow you to text on Sundays and certain holidays. Keep that in mind, of course. Don't text at the wrong time. You know, folks don't really like getting messages during dinner time or Sunday nights or when they're driving in rush hour traffic. Know your consumers and, you know, when they'd be appreciated be contacted by you. And then, you know, while your text messaging platforms may have best practices and maybe using outside counsel such as, you know, Eric and Drips and them working together, make sure you have a compliance department that's reviewing these scripts to make sure that you're continuing these best practices. I think that's really important, especially for me. You know, while I trust companies like Drips fully, you know, I on my end, I also got to be seeing what's being sent out to my consumers.
Trust but verify.
So.
All right, well, that's our show, I think. Neil, if there's any other questions, we can jump on for a couple additional minutes here. Apologies to everyone that we didn't get through all the content, really a downer. But to your point, Neil, we'll be back next month. We'll have more.
Yeah, we'll definitely continue this conversation. There will be there are a bunch of other slides, so please re-engage with us as this content. We'll address it up. Once again, I know the first Wednesday we're going to probably launch these master classes, and we will get to all the content. A couple of closing thoughts. You know, consent is everything. It answers a lot of questions. We know that legislation can go one way or another. We know some of the states, right, Eric, are considering their own definitions of an ATDS. You have state rules for deliverability, and as AC said, hey, go out and blast a bunch of messages, but the carriers may go, nah, not so fast. And even for your mobile phones, make sure you still have consent. That wireless recycled phone base is not going away, and it's still part of your deliverability. You know, so wireless reassign, I know we're still running it for a lot of clients on that, followed up with a DNC. So all this stuff is designed to keep you out of trouble in what's going on. And in all cases, if you don't know, if you're not sure, AC talked about intent. You know, experts like Eric get a third party to come look at it. I know when I dive in, I look at, you know, what the vendors are doing and what the consent is doing and what your practices are. So at any rate, let me go around the room. Pooja, what are you doing? So are you making any changes to what you're doing? Or are you just—
Neil, you know, short answer is no. If anything, I'm having a closer eye on folks. You know, as I mentioned, while I have companies and vendors I work closely with that I trust and know that they also follow those best practices, you're constantly going to get new requests for new vendors. So I myself am just keeping a sharper eye on the onboarding process and making sure that the folks that we're currently working with aren't changing their practices. And I'm also just communicating more with them to let them know, to make sure you're on the same page and that there's no change of wave in the industry and the folks that you're working with.
That's cool. AC, I'm going to throw that same question from, you know, not only how you're interacting with your clients, but on your platform as well.
Yeah, I think it's exactly what Eric said. I think those places that made sense, that the TCPA, you know, essentially stopped companies from doing things that made sense for the consumer, we're going to start looking at those places. That I think is smart and interesting. Again, the missed call probably being the most obvious, right? You call creditrepair.com and, you know, your intention was to talk to them, and prior to this, they weren't allowed to use systems to you know, to automate that. And they get thousands and thousands and thousands of calls a day. They run commercials, et cetera. So it's those places. It's the places that make sense for the reasonable consumer, I think, is where we're going to put our focus as far as any adjusted business practices on our side.
And probably also, I know a lot of people are talking about business to business, but there's still a gray area that's not been addressed by the regulators, and that's a small business who uses his personal mobile phone. Eric?
Yeah, I'm going to put together, Neil, an analysis, like I've done these flow charts on B2B. It's going to be on tcpaworld.com by the end of the week. If you don't know tcpaworld.com, you should be checking it out. No barriers to our content, free information. We break down everything very timely. Best and most comprehensive TCPA coverage on the internet. I guarantee it because I'm the guy that oversees it. But the one thing I do want to just remind everybody, we didn't talk about personal liability too much. That Allergen case spooked me because, I mean, these are people that were officers that set up the campaign and they ended up personally being potentially liable for, I mean, we're talking about hundreds of millions of dollars of their personal money, and their personal house is on the line. And I mean, that stuff can be avoided if you talk to outside counsel, right? Get yourself outside lawyers and they can give you advice. And now it's no longer you who has personally participated in creating something that might violate the TCPA. It's your legal counsel that has blessed everything that you're doing. And that's how you protect yourself from that. That's, you know, again, I've said it many times, the TCPA is the most unfair law in American history. And Facebook makes it a little bit better, but it's still incredibly unfair when people who are just trying to do their jobs for their company in good faith can get sued personally for outreach errors and mistakes. It's terrible. Use outside counsel.
Absolutely. Hey, I want to thank our guests today. As always, you guys are awesome. I want to thank everybody that's joined in. As I said, I think we've got my contact data. Please feel free to reach out. I will get answers to your questions. I'll make sure that you're connected with Eric on TCPA World. If you guys aren't reading that, you really, that needs to be required reading in today's world, trying to navigate this stuff. But we will get your questions. You can jump on my calendar. We'll make that happen for you. Sign up for the next level of masterclasses. Those announcements will be coming out soon. And with that, I want to thank everybody, both panelists and attendees, and have a great day.